Do patients have a right to a copy of their records? Who owns the patient record after all? Well, the privacy rule grants patients a right to have a copy of their records. Then the HiTech Act, which was passed in 2009, expanded that patient right so that if the dental record is kept in any electronic format, such as an EMR or a digital X-ray, then the patient has a right to request a copy of those documents electronically. I'm frequently asked the question, though, can you withhold the patient record if they have a balance? And the answer is absolutely not. Under no circumstances are you allowed to do that. And here are 3 obligations to keep in mind when it comes to patient rights and getting a copy of their records. Under the federal law, you're required to provide your release of records form in different formats for the patient. They can have the form emailed to them, faxed to them, put in the U.S. mail. You can even have a copy of that form on your website. You are not allowed to ask the patient to come in, though, to fill out that form. A second obligation is that under federal law, you have 30 days to provide a copy of the record to the patient. Please bear in mind it's a good idea to check with your State Dental Practice Act, because if that time frame is shorter, you may actually have a shorter time frame to release the records, because typically the more stringent law prevails. And third, you cannot require the patient to come in person to pick up those records. It is important that you have a process in place, though, for releasing the records, especially if the patient is sending a representative on their behalf whom perhaps the office doesn't know. How will you go about verifying that person's identity, and how will you confirm that that person actually represents the patient's wishes? Here's a quick story about what happened to one of our clients. A pediatric patient was transferring to another office. The mother had requested the X-rays and the chart. Over the next 6 or 8 weeks, the new practice called several times asking for copies of the records, to which the client replied they'd put it in the mail. Well, fast forward from there another 6 or 8 weeks, and now the mother's calling. And as the old saying goes, she's madder than a wet hen. Finally, the client resolved it that day and made sure that the new dental practice got a copy of the patient records. Phew, they thought the whole issue had been solved. Well, let's fast forward again another 6 to 8 weeks ahead, and the office receives a letter from the Office of Civil Rights. You see, the mother exercised her legal right to file a complaint with the Office of Civil Rights, who serves as the HIPAA police, because their rights had been violated. Thankfully, it was more of a letter of guidance. The letter indicated that the office had violated the law and listed out the sections that they violated, had indicated to them that this is what they should have done instead, and to be sure that it never happened again. So thankfully, that was an open and closed book with that story. What if that parent had decided to exercise another legal right, though, and file a complaint with the State Dental Practice Board? At that point, then the doctor's license could be jeopardized, because now we have a violation of a state law. So it pays to be sure that you understand the release of records requirements under HIPAA, and to have a current policy and procedure in place, and that your staff is well trained on that policy and procedure.